got enough?
This is the House Judiciary Committee. It is the 25th of March. It's a little almost whatever, about 5:20. Who can say? Senator Kagan's here. We have her bill, Senate Bill 81. I'm just going to start taking them and rolling them. I have Senator Kagan as the sole witness. This is a cross file of a bill. Is it in the same posture as the House? Okay, not yet. All right, tell us about the bill.
Thank you, Mr. Chair, colleagues and friends. For the record, Cheryl Kagan, very proud to be the senator for Gaithersburg and Rockville. We all know about cyber attacks. We all know that we are vulnerable, whether it's CrowdStrike or the Anne Arundel outage and all that. Our 911 centers are literally about life and death. We need them not to be cyber attacked. This committee and this body has heroically and ferociously passed this bill strongly, I believe twice. The Senate, finally, with due respect to my Senate colleagues, has seen fit to amend the bill and pass it out. We would love it if you would find merit in the Senate version of this bill so we can protect our 911 centers from cyber attacks. And I'm happy to take any questions.
And what's the difference?
They just tweaked the penalties.
They tweaked the penalties, all
And
right?
Delegate Hill is good with the version, if that matters in this committee.
We will look at the penalties. Are there questions for Senator Kagan? Seeing none, we thank you very much.
Thank you, Mr. Chair.
right,
Good to see you all. And
right.
Congratulations on surviving a very long day.
Well,
Yeah.
we're not done surviving yet.
I
We're
know.
going to keep surviving, I think, this evening. Going to do the two bills because Senator McKay is sitting there and, you know, he gets angry. We just don't know what to do. Senator McKay, Senate Bill 421, please. I believe this is a clean cross-file of the bill that was already passed in the House.
That is 100% correct, sir.
So we did exactly the same thing.
We did, sir.
All right, does anybody have any questions for Senator McKay? Wait a minute, it's slightly different. Okay, it is slightly different. What is?
I apologize, sir. It is slightly different.
Tell us what the difference is, please.
Absolutely. We struck the word landscaping, and we also added the words at any other part of the grounds of the cemetery. In the code, landscaping is not well defined, so that's why we struck that out. And like I said, added any other to the part of the grounds of the cemetery.
Any questions for Senator McKay? Seeing none, thank you very much for that bill. We'll go to House Senate Bill 455, please.
Now, 455, I have one witness, please. This is a new one.
That's fine, and this is a new bill.
That is, sir.
This is a new bill. So Senator McKay for 3 minutes and Evan Avnet.
Yes, sir.
All right, for 2 minutes. Please go ahead, Senator.
Certainly. Thank you, Mr. Chair. Thank you, Vice Chair. Thank you, members of the committee. Proud to be Senator Mike McKay representing Appalachia, Maryland. Senate Bill 455 empowers security agencies to hire and manage special police officers, allowing them to be assigned directly to the client's properties instead of being limited to the positions as an in-house security at those properties. Now, currently, the law restricts this hiring capability solely for the property owners, which brings about several significant changes. The bill also allows security agencies already licensed in the Maryland State Police to hire and manage special police officers. By law, these licensed security agencies are required to have either 5 years of prior law enforcement experience or 5 years of experience as a licensed investigator, ensuring that they possess the necessary expertise to oversee these officers effectively. According to the bill enhances the liability protections and the accountability for the actions of special police officers will lie with the security agency and subsequently the property owner, establishing an additional layer of insurance that does not exist for the properties employing their own special police officers. I urge a favorable report from this esteemed body.
Sir, go ahead, 2 minutes.
Thank you. My name is Evan Avnet. I serve as the president of the Maryland Investigators and Security Association. And what the senator said is all correct, in that SPOs currently exist in Maryland. All this bill is doing is allowing them to be employed by directly by security agencies. And this solves a lot of problems. So currently, smaller properties such as HOAs, apartment complexes, or lower income areas or culturally disadvantaged areas can't afford to hire SPOs because they can't have a full-time security management staff there to manage these special police officers. So therefore, they're restricted to only hiring security officers who have no detainment authority. So this already exists, as I stated. This is not expanding their powers in any way. SPOs are still restricted on their property that they're licensed to perform the special police activity on by the state police. And this currently is in effect with a lot of neighboring jurisdictions, including the District of Columbia. So in that effect, nothing changes. It's just allowing special police officers to be employed by security agencies and not just by the properties themselves, whereas those properties tend to have to be more affluent in that they can have a full-time security director. And I'm happy to take any questions that you may have.
Simmons.
Thank you, Mr. Chair, and thank the panel for coming. Can you just explain to me the authority of a special police officer, what kind of,
Sure.
best powers they have?
Yeah, sure, absolutely. So special police officers licensed by the Maryland State Police, they're sworn. They have to undergo mandatory training by the Maryland Police and Corrections Training Commission. They do have arrest and detainment authority, but it's only limited to the property that they are licensed to provide those services to. So essentially, when they step off that property, it evaporates unless they're in pursuit of a suspect that has committed a crime on their assigned property. So it's not expanding, this bill doesn't expand their jurisdiction at all. It just allows them to be managed by a security agency. Sure.
Delegate Crutchfield.
I was just wondering about the liability. You mentioned that, Senator, that there was a kind of a difference in that now liability would be, I guess, there would be co-liability between the actual security organization and possibly the site that they are assigned to.
So I'm going to ask if he would answer that question.
No
Sure.
problem.
So currently, when a special police officer works for just a property, the property has general liability. It may not have assault and battery liability, so on and so forth. If they work for a security agency, not only does the property have general liability, but the security agency, by law, is required to have additional liability insurance, specifically, generally speaking, assault and battery insurance. I don't know any security company that doesn't. In addition to the property's insurance. So that allows an additional layer of insurance protection that doesn't currently exist if the SPOs are employed directly by the property.
Okay. Thank you very much.
Yes, ma'am.
Any
It's
other
always good to
questions?
phone a friend.
Any other questions for the panel? Seeing none, thank you very much. That concludes the testimony on Senate Bill 455.
Thank you. I appreciate it.
Thank you, everybody.
All right, Senator Folden is here. Going to keep knocking out senators, and then I'll go to the administration. Senate Bill 533, which is a little bit different. Senate Bill 533, sorry, 533, Senator Folden. Go ahead.
Thank you, Mr. Chairman. Madam Vice Chair, who's out of the room, esteemed colleagues, members of Judiciary, for the record, William Folden, State Senator representing District 4. Before you today is Senate Bill 533, the Public Safety Police Accountability Time Limit for Filing Administrative Charges. This is really a cleanup bill from the MPAA of 2021. In this bill, so what this bill does, the impetus behind this bill is there are members of the law enforcement community who have been involved in an incident where there may arise criminal charges as a result of their misconduct. Currently, the ACC has to receive a complaint or a complaint when it's received has to be heard and adjudicated within a year and a day administratively. However, law enforcement, some of these members that are being investigated, their trials are being prolonged, and to start the administrative charging parallel to the criminal case could compromise the criminal case. If they don't start it, it's going to go beyond the year and a day. So what this bill does, in short, is it cleans up the language and it makes it to where it's a year and a day for misconduct that is criminal in nature from the adjudication of that trial. They have a year and a day to go to the ACC. And then the other portion is that an incident involving a member of the public with no criminal activity, that it would be the year and a day rule would still apply, that it should be adjudicated. So this is really a cleanup bill. And what we don't want to have happen is through inaction is that have an officer who is investigated criminally and the trial is prolonged and adjudicated after a year and a day, and then the agency goes back to discipline and they're unable to discipline because they're outside the year and a day. That's what this bill is about. So with that, I would ask for your favorable report on SB 533, and I'm happy to take any questions.
Any questions? Delegate Williams.
Hi, Senator Foley.
Hey, Delegate, how are
Good to
you?
see you again. I know we had a House version of this bill that I think we passed out slightly different than this version. I don't know if you have an opinion about the House version.
I do.
Okay, love to hear it.
So the language that was struck on page 2, line 3 and 4, that language has to be reinstalled, put back into the bill. It changes the bill for an incident involving a member of the public. When you've taken that out, you're taking out the incidents of involving a member of the public, which is why that paragraph exists, separate from the criminal part. So that, I think we can all agree on. I've spoken to the different stakeholders. I tried to meet with the vice chair the other day. She was busy for a while, so I think your receptionist didn't like me too much hanging around, Mr. Chairman. It was all. She said she was passing along your word, so I decided to leave. And then, you know, my on the original language to have the date by the appropriate official employed by the law enforcement agency became aware of the incident, that's really interchangeable. That's a stylistic change. It is the same as the filing of a complaint by a citizen. It's just captured. A lot of the agencies now are capturing these because you're required to have it on your website. A lot of these are captured by the submission once it goes and electronically submitted to internal affairs. So that's a stylistic change. The last part, really, we can, you know, I'm amenable or whatever, but the first part on line C is crucial, is very important to keep in.
Okay, thank you.
Thank you. So in other words, what I think the main change, the main difference is in the last sentence in subsection C on between lines 9 through 11, if I'm not mistaken. Am I reading that right? Right. So we just returned the language back to the filing of the complaint by the citizen because it is fundamentally the citizen who is filing the complaint with the Administrative Charging Committee. And part of the challenge has been that in some jurisdictions, there's been a delay between the time that has been put in and the time that it actually gets to the ACC.
So that, again, I'm amenable to that, Mr. Chair. I don't want the bill to get held up on that. I understand. I think we're both asking for the same thing.
I think so too. But I think that was really the only main change.
In section C, 3 and 4 had been struck out by an amendment you guys offered as well.
All right, well, we'll take a look at that.
That needs to be put back in.
We'll take a look at that as well. Delegate Phillips, then Cardin.
Man, I got to stretch my neck out here.
Yeah, that's all right. Senator Foley, thank you, Mr. Chair. Senator, it's always good to see you.
Good to see you.
I just want to throw out, and you know, here we do hypotheticals, so I would just want to make sure how this would work.
Sure.
I've got a criminal complaint. I've got multiple officers involved. There's a criminal complaint. One officer may have been determined that was not involved in a criminal way.
Correct.
Okay?
Yes.
When would that time start running for that other officer on the administrative piece? And I'll combine this with a a citizen then comes in 6 months later and says, I've got a problem and this officer was involved. I mean, I just get confused with all of these timelines and.
So I just want to make sure I'm understanding what you're saying. You're saying that there's a couple officers involved in an incident where criminal misconduct may
have
is being
occurred.
charged.
But there's a third
There's
officer.
a third officer who's
who
not,
who
who's
they
found to be not criminally involved.
But they haven't decided that because they got to wait until they deal with all of them to make that determination that that one officer.
Administratively is what you're saying, for
Right.
the administrative portion.
Yes.
So you're saying that there could be an administrative charge against that person.
Yes.
With the other two, but the disposition. So in that situation where you have multiple, depending on the severity of the act, obviously, the member that's not criminally in charge can be put into a light duty status. They can be,
But when would the time start running?
So on theirs, because theirs hasn't been, are you saying theirs has been adjudicated already? Theirs has been said that.
It may not be adjudication. They've just decided they're not going to do any kind of action against that
So
particular.
once they
officer.
decide, their year and a day would start once the charging authority, the state's attorney's office declines to charge. So
okay.
their year and a day, and all these, and each officer is investigated individually.
Right.
So they're all sealed and investigations that go on. So there would still be the rules of evidence in that situation where they're not allowed to talk about the case amongst each other. Those rules still apply to the rule of witnesses, I'm sorry.
And I just want to make sure this language kind of takes those things into consideration, and that's what I'm confused about.
Yeah, this language doesn't change anything. The only thing this does is it allows those officers that are charged criminally that when there's a disposition given or the charging authority declines to charge, that the year and a day starts then, that we're not waiting 3, 4, 5, 6 months. And then, because the initial complaint was received on this day, but we've waited 6 months to charge, now what's happening is they've only got 6 months to then finish the investigation, do the inquiry, have the trial board, and have it submitted to the ACC. That's a much narrower timeline when we're talking.
And I got it, and I agree.
This cleans that up.
Right, okay.
This cleans that up and allows it to be an efficient process for accountability of the officers. So we're not unable to charge.
Okay.
I should say investigate administratively. I'm sorry. I apologize. Let me clarify that with language.
I think so.
Thank you.
I think so.
Thank you.
So we think, council and I think we've maybe figured it out, where it's lines 9 and 10 need to come back in. But we took that out in the House version, but we
Yes.
returned the filing of a complaint by a citizen back in.
Correct.
And so we have to,
Right.
I got that. Okay, so at least we've identified the problem. Delegate Cardin, is that what you?
And I'm happy to come over, Mr. Chair, and figure out the finals,
So
make sure we're good.
the language in the amendment.
Delegate Cardin.
Thank you, Mr. Chair. Thank you, Senator, and appreciate it. And I think we just need to make sure that the FOP, the chiefs and sheriffs, and everybody are okay with this language. But I think the language that was put in the amendment that's going to be provided, which I reviewed with you, it only deals with shall be completed within a year of day after the filing of a complaint by a citizen. So that's the only thing that we're. So
That's the only change now.
That's going to be the only change, and it's going to be and all the fluff before that but doesn't have an impact on anything. As long as we're okay with that, and we'll check with those guys, I think that we're.
Yeah, and I've just spoke with them. I know that we're fine with that. I just know that there was concern because when I saw that the change had been struck out, those 3 and 4, I believe, I was like, that changes that. Like, we can't do that. We've got to go back.
So, Mr. Chair, we have the amendment drafted. I've got it drafted for this bill, and I've had it drafted in my name for my bill that's over with you guys.
Okay, yeah, like I said, and we can merge that together.
Okay.
Or you can merge it over when you come over here, Mr.
Okay.
Chair, so.
Fair enough.
Any other questions? All right, seeing none, thank you very much. Going to go to administration bills here, start rolling through those. Senate Bill 197.
My excuse, Mr. Chair.
Yeah, I guess.
Thank you.
Senate Bill 197, Christopher Toms, is that you? All right, great. We'll hear from you for 3 minutes on this bill, which does not Oh, no, that we passed, let me just make sure. Did we pass it in the same format as the one that we've got before us?
Similar, and we like both sides of the amendments.
All right, so what is the difference between the way that we passed it, the way?
Just different drafting.
Okay, well, tell us about that, and we'll go from there.
Well, good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the Judiciary Committee. For the record, my name is Chris Toms, and I'm the Legislative Liaison for the Department of Public Safety and Correctional Services. I'm here to testify in support of Senate Bill 197. Senate Bill 197 adds the Director of Parole and Probation to the membership of the Maryland Correctional Training Commission. Additionally, we welcome the amendment that was added by the union to add an agent of the Division of Parole and Probation as a member. We consider this a friendly amendment. DPP is housed within the department and operates 37 field offices across the state, supervising over 42,000 individuals in the community. Since the establishment of the Correctional Training Commission in 1971, the role of the correctional professional has significantly evolved. The commission now establishes selection and training standards for correctional officers, including parole and probation agents. Including the director as well as a DPP agent on the commission is pivotal as it brings in direct insight from the parole and probation sector, which is crucial for developing comprehensive training programs that address the entire spectrum of correctional services. I respectfully request that you support SB 197, and I'm happy to answer any questions you may have. Thank you.
Questions? All right, seeing none, that concludes the testimony on Senate Bill 197. Are you doing Senate Bill 202 as well, or someone else? Senate Bill 202?
Chris, you're welcome.
We're going to add ass. Yeah, that's fine.
Well, I mean, we have languages.
Go ahead with Senate Bill 202.
Good afternoon, Mr. Chair, members of the committee. Catherine Kelly, Maryland State Police Government Affairs Unit. I'm happy to report that JPR passed House Bill 259 today, the preferred version of this bill. If you could conform 202 to House Bill 259, we'd be ever so happy. And I'm happy to answer any questions or go over the differences.
So we're taking the House version and making Senate Bill 202 look like the House version.
Yes, sir.
We like doing that. Are there any questions? All right, we got it right. That's one. Thank you very much. That concludes the testimony for Senate Bill 202. And that's a conform. All right, let's go to expungement now. Senate Bill 432. Go right ahead.
Yes, thank you today. Again, thank you, Mr. Chair, members of the House Judiciary Committee. It's great to be back. For the record, Miles Hicks. I serve as Deputy Legislative Officer to Governor Moore. A couple weeks back, I was actually here for House Bill 499, which is the cross-file of this bill. It's still in the possession of this committee. Across the street, the Expungement Reform Act has been amended, but I will also report that 3 major parts of this legislation remain intact. The first reverses the Abishek decision by the Appellate Court of Maryland and clarifies that an individual who completed their probation, parole, or court-ordered supervision is eligible for expungement. You'll see in sections 110 and 105, we've added additional language in 105 to ensure that this discretion can be leveraged for PBJs as well. We also cleaned up some of the language to ensure that this doesn't just apply to probation, it applies to probation, parole, or court-ordered supervision, just to conform with the definition of completion of sentence. The second part of the bill I'd like to highlight is that this legislation would expand the list of expungable charges to include driving without a license, using a stolen credit card, and obtaining property or services by bad check. As amended, this bill would no longer add the following charges to a list of expungable offenses, and those are counterfeiting prescription, resisting arrest, making a false statement to an officer, and making a false statement to an officer while under arrest. Those 4 have been removed from the bill and a crosswalk of all those sections in code can be found in my written testimony. The final part of this bill has to pertain to judiciary case search. This legislation expands the list of dispositions that are removed from public view to include stet charges and removes all convictions included within the governor's canvas pardon from public view on judicial case search. And at the request of the judiciary, we pushed that effective date back by 30 days. With that being said, again, thank you guys for voting the abstract bill out last year. Thank you, I know she's not here, but Vice Chair Bartlett for all her work on the bill, and here for any questions.
Question that has come up from council is about 8106, which is basically a penalty provision as opposed to an actual crime. And I think I remember looking at that and wondering, is there a reason that you picked 8106?
8106 was actually one that was provided, I believe, from the advocates for, that's issuing a bad check. Happy to coordinate if there's any recommendations from the committee on a different charge or that you guys like to offer, but that's the one that we got from.
We'll look at it again, just to
I'm
make
happy
sure.
to, yeah.
Yeah, that's fine. Questions? Delegate Grammer.
Thank you, Mr. Chair. Can you go through the list of charges which have been added one more time for me?
Happy to. So added would be 8-106, and all of this, for those who want to follow, are on page 5. 8-106 is issuing a bad check. 8-204 is credit card theft. And then 16-101, which is on page 6, is driving without a license.
And what were the ones that were removed?
The ones that are removed are 8-610 is counterfeit prescription, 9-408 resisting arrest, 9-501 false statement to an officer, and 9-502 false statement while under arrest.
Thank you.
Further questions? All right, seeing none, thank you very, oh, I'm sorry, Delegate Phillips.
I'm curious as to why those particular offenses were removed.
Yes, just of course, working with a lot of members of this legislature and also a lot of the conversations with our staff, we had 3 main goals. One was, again, adjusting that average check, making sure those people have access to expungement. 2 is expanding the list of offenses, which this bill still does. And the final one is additional shielding in judiciary case search. We still were able to do all 3 of those things, and knowing that we had those 4 removed, there were, I think there's also part of the conversations where when someone pleads down, you might get something that was an assault gets pleaded down to resisting arrest, or counterfeit prescription could be someone who is selling drugs. So there were a lot of other questions that ended up having, which led to those 4 charges being removed from the bill.
Okay, I'm a little bit concerned about some of those charges. You know, resisting arrest becomes something that is often charged. And so that's concerning to me, but we'll try to deal with it.
I hear what you say. Absolutely.
Further questions? Seeing none, we thank you very much, and that concludes the testimony for Senate Bill 432. Anybody here from the Attorney General's office? Come on up. Senate Bill 466, which we passed. This is in a slightly different posture, the Senate bill, than the bill that we passed. Is that correct?
That's correct, Mr. Chairman.
Can you talk to the differences between the 2 bills, please?
Certainly. So I believe my understanding, based on the briefing I received, was that the Senate committee worked off of the House version. So what's before you should include everything that the Senate changed and everything that this committee changed before it went across the street. The key amendments are, first, the bill now clarifies the boundaries around the language intent to deprive. There was some concern that that language was a bit too broad and might sweep up gift giving or inter-family exchanges of property. And so we've ring-fenced that by including unauthorized control as an element of the crime. Just to be clear that it's not just the intent to deprive, but actually that there's a lack of authorization. Second, the age of 68 has been removed as a qualifying factor for the added protections of the bill. That will only apply to the added language in the healthcare provider patient context. 68 still applies in the event that there's deceit or undue influence. And then finally, and I think that this was actually in the bill when it left the House, but there's been a removal of the possibility of consecutive sentencing only in this specific context, in the healthcare context. It can only be concurrent now. I'd be remiss if I didn't say I think that sort of goes counter to the spirit of the bill. We allow that in the physical abuse context. You can get stacked sentencing for abuse of a vulnerable adult and assault. So I'm not entirely certain why we wouldn't do it here. And I know that the Judiciary filed some testimony that suggested they have a similar concern. But I want to be clear, the Office of the Attorney General supports this bill in this form. We just might support it a little more if there was the possibility of consecutive sentences.
So I'm sorry, could you just, the consecutive time was in the original draft of the bill, or?
In the original draft.
We did it, so we put it in the House version of the bill, but that's not the way it passed the Senate.
It is.
Oh.
The Senate has it too, but the AG's office prefers the option of consecutive.
Consecutive or concurrent time?
Yes.
Okay.
The way the bill originally came in, the current law.
Okay.
No.
Delegate, we're going to let Delegate Cardin ask the question.
To just make sure, so the way we passed it, it requires it to be consecutive?
No, concurrent. It took away the possibility of consecutive sentences.
It took away, it could only be concurrent.
Concurrent, yes.
Okay, I got it. Thank you.
And to be clear, that means you can charge 2 crimes, but you're going to get the same result as if you charge 1 crime.
Yeah, okay. That's fine. Delegate Embry.
Just to finish this out, could you give an example where it would be helpful to have consecutive time, where it would cover 2 different behaviors?
Certainly. So, like I said, this is already allowed in the physical abuse context, where you would charge both assault and abuse of vulnerable adult. If this bill were to pass, if a nurse or a GNA were to steal from a nursing home resident, for instance, we could charge theft, but we could also charge financial exploitation of a vulnerable adult. The benefit of this bill and of stacking those charges is that you can now, if you're convicted of both of them, you can be sentenced concurrently. And that matters because at sentencing, you're going to hear about the sentencing guidelines. And most of the people that we find financially exploiting vulnerable adults are first-time offenders, which means their guidelines may be probation to 3 months, which means they very rarely get any significant punishment. And so being able to charge both crimes and sort of recognize both wrongs, both the theft and the violation of a vulnerable adult's trust, allows the court to craft a more appropriate sentence. They don't have to, but if you allow concurrent and consecutive, they can. It gives them that discretion to form case-specific appropriate sentencing.
Delegate Conway.
Mr. Chairman, thank you for coming in to testify. As I recall, I think the reason you wanted it to be concurrent was that it would stay on a visible record longer. Is that correct? For future employment?
That has to do with where it is in theft versus exploitation. If you have a theft on your record, it's fairly easily explained away to future employers in long-term care. Exploitation is not.
Thank you very much.
So basically, as it's drafted right now, being concurrent, you would either get, I guess the penalties appear to be the same as theft and everything else, so it would be one or the other.
That's
not
correct.
both. So you would be kind of left in the position of not really knowing what the actual or the mistreatment of the vulnerable person was in some ways, because you'd know that there's the mistreatment of the vulnerable person, but you wouldn't know if it was for a theft or for something else.
That's correct, because that's a very good point. We would only charge the exploitation, because charging the underlying crime as well doesn't have any practical effect.
Okay, Delegate Phillips.
So we debated this quite a bit. The idea that a person would receive consecutive time for the same set of facts, I think, was the issue. When the bill was presented, it was presented with the idea that we needed this to ensure that the individual would not be, that would be prohibited from actually being a caregiver, right?
Yes.
And so that was the concept of the bill. It wasn't about the penalty. It was about making sure that they wouldn't be able to go and do this with someone else. Is that not correct?
It was both. Certainly, exploitation makes the exclusion program in the federal government that you're referencing much easier. It's very clear cut. But in addition, we do, as I noted, allow consecutive sentencing and physical abuse, and we were just trying to equate it because we're seeing more financial abuse now. And it's no less a violation of the trust and the value of the vulnerable adult. So we just wanted to put them on even footing.
I would say physical abuse and financial abuse are both terrible, but physical abuse, I would suggest, is worse, and it probably deserves a consecutive sentence, in my opinion. But, Mr. Chair, that was what we debated very significantly. I just wanted to make that point.
Are there any other questions for the witness? Seeing none, we thank you very much, and that's going to conclude the testimony for Senate Bill 466. Now, lots of people walked in, including the chair of the Judicial Proceedings Committee, who we are going to torture. Who we welcome warmly, Senate Bill 873, a work group. Senator 873.
Work group.
Sorry.
All right. Thank you for that introduction, Mr. Chairman. Senator Smith here to enter into the record Senate Bill 873. It's good to see you all. Thank you for your work today on the budget. Today, the bill that's before you today is simply a work group. Obviously, in Maryland, you've got assault in the first degree and assault in the second degree, and assault in the second degree covers a broad swath of activity. We have passed in prior years a work group to do a crime classification work group to kind of understand the web of crimes that we've created over a series of years that at all times don't quite make sense. So what this is an attempt to do is to look into the prospect of creating an assault in the third degree. The work group members are on page 10 of the bill, which is largely struck, and I won't go through all the work groups. I think you have a couple of amendments before you, one of which I sent over. One is to ensure that the Office of the Attorney General is not staffing it. I think it's going to be relegated to DLS. Another one is to add the Coalition for Defense bar, and then I think you have two other amendments, which I haven't seen, but I have understand in concept that add two other members from the victims' rights organizations. So I view those as friendly amendments, and with that, Mr. Chairman, happy to rest and yield for questions.
Questions? Seeing none, that concludes the testimony on Senate Bill 873. Then we're going to Senate Bill 391, please, and this is also a bill that's due to the committee. Senate Bill 391.
Thank you, Mr. Chairman, Madam Vice Chair, distinguished members of the Judiciary Committee, Senator Smith here to enter into the record Senate Bill 391, which essentially a couple of years ago we created the Independent Investigating Division within the Office of the Attorney General. That division publishes an annual report which was required by statute. It's very detailed. If you go onto the website, you Google OIG, AG, MD, you'll get to this website and it'll give you a dashboard of information of where all the officer involved deaths have occurred. You'll get demographic information. You'll get how that person expired. You'll get all of this information that we can use to make future policy decisions on how, for a multitude of different things, like whether we need to invest more resources in a neighborhood or what the policing looks like in a certain jurisdiction. So what this bill does is says, look, the MPTSC, the Maryland Police Training Standards Commission, has to look at that study every year and make recommendations to improve policing. This bill was done in consultation with the MPTSC and the Office of the Attorney General. Both organizations have endorsed this and worked with me, so it just simply says they have to study it, look at it, and adjust fire as they see fit moving forward. So with that, Mr. Chairman, I'll conclude my testimony and ask the committee for a favorable report and stand by for questions.
Any questions? Seeing none, thank you very much.
Thank you all very much.
That concludes the testimony for Senate Bill 391. Go now to Delegate Sidnor, former Delegate Sidnor. When I first started here, he was a delegate. Look at how he's grown. Senator Sidnor, Senate Bill 343. Senate Bill 343 is here. We'll hear from him and from Heather Warnken.
Thank you very much. Good I guess it's evening?
Pretty much. Yeah, come on.
Good evening, Mr. Chair and members of the Judiciary Committee. Senate Bill 343 may sound somewhat familiar because what it does is it picks up and expands on Chapter 141 of 2022 by reconstituting the task force to study transparency standards for the state's attorneys. In fact, Delegate Moon, he served, I believe, as my co-chair on this particular task force. So if you have any questions about it, please feel free to reach out to him. He's our resident expert. Why do we need to reconstitute the task force? Because honestly, our work was not done. The task force was appointed late, so we rushed through attempting to address the tasks that were set forth before us. And while we were trying to do the work of looking at the types of data and the like that state's attorney's offices would necessarily collect, what we found out were that there were some state's attorney's offices that did not have case management systems. And so rather than fulfilling our charge, we spent a good bit of time trying to look at how one could then ensure that our state's attorney's offices across the state had case management systems. So as amended, Senate Bill 343 reinstates this task force, which was established. We are noted in Section 3, what we're attempting to do is to bring back and secure as many former members who were on the task force, the original task force, to continue serving. But as I mentioned in 2024, unfortunately, this task force had expired when we attempted to have legislation put forth last year. One of the things that we also had done last year was to create a grant for state's attorneys' offices who were looking and working towards putting data dashboards and making their information publicly available. Unfortunately, last year and this year, the Maryland State's Attorneys Association, they fought us. They didn't want this. In fact, if you talk again to Delegate Moon, he can really explain to you the position that the State's Attorneys Association were taking. They tended not to work with us as we were trying to gather information, and they became an obstacle, in my opinion. Are we get timed here?
Yes.
Oh, my Lord. Time. Oh, I get it. So look, with this as amended, we no longer have the grant, but there is, like I said, there's a grant that's being run by GoCap right now that many offices have applied to. What we're hoping, and one of the things that we did is we put that as one of the other tasks, is that we're going to look for money so that we can make this data or make monies available for state's attorneys' offices that want to do the kinds of things that Baltimore City is doing, that Montgomery County is doing, that Frederick County is doing. So the fact of the matter is, this is not a partisan issue. You have Republicans and Democratic state's attorneys who are doing this. Thank you very much.
Okay, good evening, members of the committee. Heather Warnken from the Center for Criminal Justice Reform at the University of Baltimore School of Law. I was appointed by Governor Moore to serve on the initial iteration of the task force, and as Senator Sidnor already explained, our work was just beginning. So I'm grateful to testify in strong support of SB 343. So as you know, prosecutors are widely understood to be among the most powerful actors in the criminal justice system. They wield tremendous authority and discretion, deciding which cases to indict, which plea offers to make, and numerous other decision points impacting the lives of not just people accused of crimes, but their loved ones, victims of crime and their families, and society writ large. There has been a groundswell of energy and investment across the country in the need for data-driven systemic reforms, especially in the past decade. I've submitted extensive written testimony speaking to this, but I'd like to underscore just a couple of reasons of why we view this bill as so important for Maryland, directly informed by my experience on the task force thus far. So firstly, advancing both the infrastructure and the culture change needed for quality, consistent data collection at the county and state level is a long road. And again, this work has just begun. SB 343 extends the life of the task force to examine these issues, implementation questions, funding sources, and help steward a path forward toward greater equity, systemic legitimacy, and research-backed change. The bill also expands and diversifies the task force membership to include needed perspectives. And again, I would just point to our written testimony, which doesn't just outline all of the benefits of this work. It does it through the lens of state's attorneys themselves across the state of Maryland and across the country about why this benefits their work in terms of efficiency, resource allocation, and so much more. So we urge a favorable report.
Delegate Sample Hughes.
Mr. Chair, and I know I could ask my seatmate all this, but I'm just got one question. Isn't there a system that the state's attorneys are already putting in data at this time across the state, or no, that doesn't exist?
No, it doesn't exist.
Okay.
Different states' attorneys' offices have their own case management systems. And as I said, when we were initially constituted, we found out that there were some state's attorneys' offices that did not have case management systems. Hence the creation of the grant that I think was just put up, the RFP was put out, I think, back in February, and there have been some offices, I think Frederick County was one, that state's attorney's office was able to get some funding. So the answer is no, there is no one uniform system. That's something else that we want to look at, because right now you have state's attorney's offices with 3 different types of case management systems that they don't speak with one another. And again, if you were to talk to the Maryland State's Attorneys Association, there's been some disagreement even about that. You have some who are looking for back in the day, they looked to have one uniform system that all different state's attorneys' offices would have had. But because that did not happen, you had different offices moving in different routes and using different systems. So one of the goals that I would hope after looking into this problem is trying to figure out how these systems can talk with one another, figuring out how much those costs are, looking to make certain we were able to get the money so that these state's attorneys that want to put those patches on those systems so that they can speak to one another would be available.
Okay.
I think it would make Maryland much safer than what we are. And if I may, I forgot, Mr. Chair, Delegate Crutchfield, I think the first iteration of this bill, she was my cross-file on, so I wanted to make certain I said that on record as well.
Okay.
Hello.
I have two questions.
Yes, ma'am.
Two simple questions. Is it true that GoCap has a system?
No.
So GoCap.
GoCap has a system that draws from the case search. That's judge data. We're talking about state's attorney's data. Now, some of this data may overlap, but much of it does not.
Okay. What's the difference between the system with that? I think the clerk's office put that system in, right? The judicial data, the clerk's office put that in, the clerks and the judges, I would think.
You
They
have
set
different
the trial
actors that are
dates.
sending that, putting that information in.
So the clerk set the trial dates. or whatever, the judges, so they have those combinations, so, I mean, they input that data. Could you tell me a difference between what's basically with what GoCap data is and what the data you're saying is different from his state's attorney's office?
There are a lot of
Briefly, sorry.
those data points that don't even exist. So we're talking about lots of different points of case processing, the decisions that state's attorneys are making around things related to pleas, which charges to pursue, the disposition of cases, including breaking these things down by race, zip code, and again, both for defendants and victims. There's so many different metrics that actually play a huge role in how these things go. And again, for most of the things that I've named, it's often a black box.
Okay, I was curious because when I was in state's attorney's office, they have a system that you input the data in, and it tells you like the police report. It's obviously within the police report, it tells you the race of the person, and it tells you all this information when you input the system in there. Are you saying, say the system in Prince George's may be different than the system in Baltimore City because, all of the sort of police, the witness coordinators, everyone is using that same system. Are you saying different counties have different systems? Because that's one system. And then on the case search, they do have that, whether, okay, it's no pros or it's, having a second or the hearing date, or you're saying, I mean, obviously it doesn't say race, but it does offer some information that could be helpful. So I'm just trying to understand. I would admit State's Attorney Association did bring it to my attention, so.
As Senator Sidnor was explaining, this is a serious justice by geography issue, where you have some counties that are much further along, that have case management systems, that have more infrastructure, and are collecting some version of consistent quality data on some of those metrics. And then you have some places that, as we learned in the initial phases of the task force, we're literally using paper files and not reporting this information, not cataloging it or collecting it consistently. And then you have a lot of counties in between. So part of what this is about is creating more consistency across the counties, understanding where the gaps in that infrastructure is at the county and state level, and then working our way towards some minimum standards and some basic metrics of accountability that we want to ask from every jurisdiction so that they can report back to their community, to other public safety stakeholders about trends.
Sorry, I'm gonna cut you off because I gotta leave shortly. So my third bite at the apple. Sorry, it's an inside committee joke, but what is the, does the Office of Public Defender have this same system? Or are we looking to do the same thing with them?
I don't know about what the Public Defender's Office has, but what we're doing is, number one, as you mentioned earlier, you have the courts that have their data, you have police that have their data, and all of this stuff has been looked at and the tires have been kicked. What you don't have, and when you're talking about the justice system and public safety, is a look at what's happening in our state's attorney's offices. This is where this originally, the idea of this originated from.
Okay.
And trying to, again, to get this data so that we can see what's happening, why certain deals are being made, how charges are moved forward and the like. So you're not going to find that in police data. You're not going to find that in court data.
Okay. All right, I'll delve into it further. I'm sorry, I have, and again, I apologize for cutting you. I have to go to a wake, so, thank you.
Our condolences.
Thank you.
That was a merge of our names. New Bradgelina. Thank you, Senator, for being here. I know you mentioned that you're trying to kind of put the old band back together. Was the Public Defender's Office a part of the original group as well?
Not to my knowledge, no.
Okay, so what was the idea of putting them into the new group?
I'm happy to speak to that. So in a number of our meetings in the prior task force, OPD not being on the table had practical implications for the discussion. So we were rolling up our sleeves, like what data is really feasible to collect? You know, what are the administrative burdens on the office? There's some things that are more cut and dry, but some things, for example, surrounding pleas, there's more gray area, there's more, you know, privacy around those decisions. And so a question would come up, and MSAA usually, you know, would be sort of the only one being able to speak to that from a day-to-day, practical, in the trenches kind of perspective. There were no practicing defense attorneys, including from OPD, who obviously has the lion's share of the cases, who are also sitting in these case processing decisions, oftentimes on the other end. So this isn't, MSAA, I know, has been very opposed to adding OPD, but it actually is just really important for the substance of the work.
And remind me again, I'm scanning the list again, are there private attorneys on the task force as it stands now?
No, there's no seat for private.
So the public defenders are the only individuals on the task force that would kind of represent the defense side.
There were certainly others who were representing that perspective, but not from a current case processing where they have over 90% of the cases.
I see like advocacy groups and stuff, obviously. Okay, so yeah, I guess, well, that brings me to my next question. So yeah, was there any talk about, instead of having the public defender's office, having somebody, you know, represent, you know, somebody from a private defense firm or whatnot?
No.
I assume there's a private defense bar or something. Yeah.
So
criminal defense bar, thank you.
And one of the things that I want to point out, because one of the things that the State's Attorneys Association has been saying is they feel that given this one seat to the public defender is going to shift the balance or whatever. But if you look at the representatives that are currently here, and you have an executive director from the criminal sentencing policy, you have a representative from the administrative office of the courts, Vera Institute for Justice, and Vera Institute of Justice, their person was a former state's attorney. Attorney Grievance Commission, the chair, probably an attorney. Crime Victims Advocacy Group, GOCAP, the Attorney General, we added the Public Defender's Office, and an expert on data and transparency, as well as members who would be appointed by the Senate President and the Speaker's Office. And as Ms. Warnican pointed out, you're just talking about one seat amongst close to 15 individuals. They're making that a big deal when in fact the big deal is the bill. They don't want the bill anymore because of, I mean, I think that their current president had been adamantly opposed to this since day one. But they've had members who we worked with. Frederick County, we worked with that office in putting this bill together, and had fully expected that when we had designated someone from the Maryland State's Attorneys Association to serve, that it would have been her. Unfortunately, because her idea, I think, and with her office's experience was different from the current chair, he put himself on, and it just changed the whole vibe of this committee and the work that we were able to do. And it continues to this through this hearing.
Gotcha. All right, thank you.
You're welcome.
All right, Delegate Simpson.
Well, I love the idea of having money-finding task forces. That sounds absolutely fantastic. So for clarification.
It's a doge.
When you're, hey, we'll take more of them. So for clarification, just so I fully understand, so when you're talking about this task force and it's for transparency, so you're trying to look at so that all the offices can talk, how can you make all of the offices or enable all the offices to talk to one another? And then like some of the issues that we keep talking about back and forth that we really don't have the data for, so whether it's demographics or like when we're talking about the
how many cases are coming from the commissioners, and then how many of them actually move forward, or particularly like, am I on the right track? So particularly like domestic violence or sexual assault, how many of them are not pursued? And we would get data on that, which we have literally none of. Or like, you know, when it comes to, I guess, confiscating guns and that kinds of stuff with the domestic violence, we would have a better understanding. Am I being correct? That we wouldn't just have information like the case search of what is founded, we would also have what's been discarded.
Correct. In fact, one of the things that I should have pointed out and that you helped to jog, again, the State's Attorneys Association, they were successful last year at killing this bill. But because of my dedication and the dedication of those who support this, what we then did, we went to the budget people and we put, I think it was $500,000 into the budget, and we put certain points of data that this task force said at a minimum these databases should have. We put that in the budget, so anyone that then attempted to receive one of these grants, that state's attorney's office would at a minimum have to collect a certain pieces of data. I think it was maybe 7 or 8 different data points. But again, as we said, there's still a lot of data that's out there. There have been, I think it was Connecticut that had a much longer list of data. They did something like this, and they had a much longer list of data that was collected so that they could get a better understanding of what's happening in our public justice system. We've gone pretty small just because of, again, the State's Attorneys Association, who many the president didn't even want the money. That's like, how many times are you fighting against agencies to give them money to make them more transparent and to make them better? The fact of the matter is, I believe his feeling was that the more information that was out there, it could be weaponized in a campaign or something. But the fact of the matter is, we're all public officials. We all take votes, and the way that those, however our votes are, they're out there and the public can use them however they choose to use them.
So in my little word quirkiness, just to clarify, because you say they, and when I hear that you were talking about it will help the state's attorney's office and be, better managing themselves, but you also mean us as well, right? So they also means that we would have a better understanding of what is occurring and being able to craft better legislation for whether it be training or efficiency. Is that correct?
Yes, ma'am, because really when this committee, when you hear bills being presented, when we over in JPR hear bills being presented, generally what we're talking about are anecdotes that are being presented. We're trying to lay a foundation here so that we can be data-driven. We can have the data. No longer do we have to hear those anecdotes about how awful someone is. We can actually have the data.
Right.
And right now we're not there. So that's for the public. Internally, what you're talking about is state's attorneys who are then able to have data to see how their prosecutors are doing. And they can weed out however they want to. I mean, maybe you have a get tough on crime prosecutor who sees that he or she has too soft of a prosecutor, right? So maybe I don't want you in my office because you're being too soft. Or maybe you have someone who is a little bit more lenient. And so, I mean, this data can be used in all sorts of ways. But again, it's not going to happen. We're not going to get there if we don't begin with something.
So it could even be an individual worker or judge. You could see which judges are really, really harsh, giving really, really long sentences as opposed to very same charges.
If that was a data point that's collected, yes.
Yeah, I would just add really briefly to that. I mean, I think you just laid out so clearly, Delegate Simpson, all the different reasons why this matters to lots of stakeholders in terms of moving us from anecdote to evidence, on resource allocation, on understanding systemic trends, and why a task force that has a diversity of voices and an infrastructure to move this along is so important, because it's complicated. How do you sustain it? How do you have consistency across counties so you can look at trends? How do you report it out to the public, you know, de-identified, things like that? And we are talking about a starting point now where we could not even get consensus that data and transparency even matter. In task force meeting after task force meeting that we had in our very truncated, you know, brief first bite at this, MSAA would come and say, you know, we are accountable to no one. The nature of our job is that we have to do what we do in a black box so that we can make an individual assessment based on the interests of justice in an individual case. If you start making us report this out, they're gonna be scorecarding us, they're gonna make it political. We couldn't even build consensus that we all care about data and then do the hard work of, okay, practically how do we do it? And it's funny that they're so categorically opposed to OPD being any part of this conversation because actually there's alignment there. Sometimes OPD is like, that's administratively too hard, or like, that's too gray, or that's, we don't, you need to pay more to be able to let us do that consistently across county. They're actually aligned, you know, and we're, you know, the researchers or whomever is like, no, we want it all. We want every detail. And they're like, that's not feasible. Like, you need this task force to make this work meaningful.
Okay. Okay. So really, the task force exists. The bill is to extend.
No,
it's
because of their effort, their successful efforts last year.
Right. But I mean, the arguments for the task force were made to create the task force that did exist.
Yes.
Okay. So just want to make sure everybody understands that those arguments have been made. The task force is good. We said it was good. Now all we want to do is to kind of resurface the task force, okay? And to have the funding for it. Delegate Taylor.
Madam Chair, well, that kind of changes my question a little bit. But Senator, is it outside of the scope of this bill to report on the number of felony murder charges?
Ooh.
It would be outside of the scope.
Thank you.
Great question, Delegate Taylor. Yeah, I like that. Okay, seeing no further questions, that concludes this panel. We're going to call up unfavorable. Hold on one second, please.
Yeah. Karen Watkins.
Oh, okay.
Karen Mitchell. Whoever would like to go first, please.
Thank you, Chair. I'm Karan Watkins of Harris, Jones, and Malone on behalf of Maryland State's Attorneys Association. As an organization, MSAA supports transparency, recognizing that data is essential to fair and effective administration of justice. Today, I'm proud to share that all 24 state's attorneys' offices in Maryland now utilize case management systems, which is a crucial step towards modernizing their operations. 3 jurisdictions in particular, Baltimore City, Frederick County, and Montgomery County, have emerged as leaders in this space. While Baltimore City has made continual progress over the past 4 administrations, when I talk about administrations, I'm talking about their elected prosecutors. Montgomery County has enlisted the support of the University of Maryland at College Park, and Frederick County is on a mission to enhance transparency. The progress of many other jurisdictions is directly attributable to the thoughtful recommendations made by the task force to study transparency standards for state's attorneys, the one we're talking about that will be reconstituted through this legislation, as it outlined in its December 2023 report. So they have a published report, and I want to make sure that we know that there was a report that came out of this task force. Most recently, the elected prosecutors from the 3 aforementioned jurisdictions traveled to Florida to participate in the Prosecutorial Performance Indicators Conference hosted by the Association of Prosecuting Attorneys. This national initiative, in partnership with Florida International University and Loyola University Chicago, is assisting offices across the country use data dashboards to better inform the public and assess prosecutorial performance. Here in Maryland, the Governor's Office of Crime Prevention, Youth, and Victim Services is in the final stages of developing, may I finish my thought?
You may finish that thought.
Thank you. They're developing a dashboard, which was referenced today, and we find that instead of mandating the creation of 24 separate dashboards from scratch, that we utilize this statewide dashboard and see what the state's attorneys can do to better support what GOCAP is already doing and is in the process of putting out. So in closing, MSA believes reconstituting the task force is unnecessary. The work of the task force is done and the roadmap is clear. We respectfully request an unfavorable report.
Thank you. Ms. Mitchell.
Thank you. Good evening. I'm Karen Piper Mitchell, the Deputy State's Attorney for Charles County, as well as a resident of Prince George's County. Sorry, thank you. Did you hear? You need me to say it again? Yes. Okay. Good afternoon or evening. I am Karen Piper Mitchell, Deputy State's Attorney for Charles County, as well as a resident of Prince George's County. I think it's critical that we go back to looking at what his GOCAP has done. We actually learned of that at the beginning of March. And I think it's also critical to understand how data goes into our systems. About more than 90% of what happens is charged by law enforcement, which means that they enter information in through the commissioner's system, which is then what is brought into our individual case management systems and the beginning of our case, from where the crime took place as the date, the address, the demographics of the individual. And a lot of what is built through the court system is also built in our systems. If there is a plea to something, then that is reflected in what we put in our databases, but that's also what's reflected in the court system. I think it's critical in light of the fact that GOCAP has created this system that we need to take the time to look at it and see what is available. It's not completely separate than the information that we build. That's the first thing. Understanding the databases, think about the databases as a replacement for paper. We went through that process and instituted ours in 2016. And so it is a move from writing things down to going to a digital system. But when you're talking about taking that information that is then in a dashboard, you have to bring that information from your database into a dashboard. And there's certain data points that have to be created to allow for that. So even some of the things that have been mentioned, you still cannot do because they're not done in a particular situation or field. What we're asking from the Maryland State's Attorneys Association is, as we all individually have continued to move forward to look at ways to modernize our individual offices and look to transparency, including Charles County. We pulled out of the situation because we realized that our database at the time was not set up to accurately reflect any information in any kind of dashboard, and we did not want to put out inaccurate information. We asked for an unfavorable with respect to this committee, with respect to this panel.
Thank you. Just a quick question. So is a report available to the General Assembly now with respect to the data that is in the 24 jurisdictions case management system?
Report? The report that I was referencing was the report that came out of the task force, but we do not have a report.
Right, I know. What I was asking was, can one be generated for the Maryland General Assembly at this time? From the case management, meaning that so I thought that part of the reason the task force existed was to provide data so that we, according to the questions that I just heard a few minutes ago between Delegate Simpson and the bill sponsor, so that we, as the General Assembly, could review information so that we could be better legislators. So if the testimony of the MSAA is that we don't need the task force because it is already being done, then I'm asking, has that part been fulfilled? Meaning that I could now say, MSAA, give me a report of your various decision-making process, decisions that you've made based on race or age or whatever.
Well, twofold. Well, what we're seeing is, one, GOCAP has put together a dashboard that we've just found out about, and I think we need to look and see what that's providing. That would be the first thing. As far as your follow-up question as to what decision was, why we offered X plea.
Not the why, because I get that. You've got to have prosecutor.
Right, so all you're going to get is the final decision, which is, case was charged, say, as a burglary in the first degree, and the case resulted in a burglary in the fourth degree. That's going to be both in our system, but that's both in the court system, because the court system is going to have what the initial charges were, and they're going to have what the final disposition is, which would be the same thing that we would have to reflect, we would be reflecting in our own systems. So there would be no difference in that.
Okay.
Does that answer your question?
Let me tell you exactly what I'm asking.
Okay.
I'm looking at some tasks that the task force are supposed to study. Your testimony says 24 jurisdictions already have case management systems.
Correct.
So that part, check. So I go back to the bill and I see one that says that there's going to be a determination of what information should be made public and what information should be kept private. Some more they're going to examine existing policies across the state's attorneys. To me, those things still remain outstanding. So that's why I was asking you if there currently is a way for the General Assembly to receive a report based on these 24 jurisdictions case management system that already exist. And I believe your answer is that the dashboard from GoCap with the Data Statistical Analysis Center, that's where we would get that information. Is that the correct answer?
You want to answer?
Understood, Vice Chair Bartlett. I think our point is that there have been recommendations made, progress has been made, all jurisdictions now have it. The issue is, I think Senator Sidnor mentioned, they are not all the same case management system. So they are not all, they don't all have the same. Yeah. However, GoCap does, and that's why we're saying, hey, we have this statewide database that the state has taken time to do that is about to be published. Let's look at that. Let's see how these 24 separate jurisdictions with 24 separate elected officials can support that rather than believing, because we talk about these things as if it's going to happen overnight. This all is going to take time. Baltimore City is leading the way and doing great things, as is Montgomery County, but it's taken four administrations for them to get to where they are in the realm of transparency. And now we have, because of evolution, because of progressive prosecution, you have this this movement of people wanting to do transparency, and it's not just happening from the outside. There are prosecutors that also want to do this. And so that's the idea. Why do we need to reconstitute the task force to do what we need to do? There's a report out there, recommendations made, recommendations that can be, addressed, that still needs to be addressed, we understand. But can we, because also the bill now takes out the funding. So it's literally just reconstituting the task force to then go and think and figure out ways to find funding when we have, we have different avenues in place, such as PPI, such as University of Maryland, such as Bowie State University. Did you want to add anything to the question, to the answer?
No, I agree. I mean, we have, the different offices have been working to see what we can do to help develop our dashboard. For instance, in Charles County, one of the things that we decided to do, we had to go back and fix our database. You have to fix like the points that you're entering, or making sure you're being purposeful about making sure that certain things can get translated into fields so that it goes in. Or we looked and we saw that actually the court system is going to have a better record of what happened with each case, because sometimes the attorneys weren't always coming back and entering the information in. They've got to go in and, and there's no AI for us just going in to automatically do that. So we were finding that the court record may be a better record of what the full breadth of what happened with that case and what we had, which means that if we feed information from our system into the dashboard, it's either going to be incomplete or inaccurate. So we had to pause in that and look at how we were going to go back to try to fix our information to make sure that it aligned. And going back as far as 2017, if we want to read as far as that. So that's the other concern. This process takes time. As Ms. Watkins said, we know what the information that we're looking to put in, and from those things that we've learned, not only just from the other 3 jurisdictions, but in meeting with jurisdictions across the country that have done that. So it's a matter of taking time. We don't feel that the committee needs to be reconstituted to suggest what should be done. We already understand that, and we're working individually to get to that point so that we can collect that information.
Thank you. Thank you for your response. Delegate Simpson?
Well, thank you very much, and I really do. I do appreciate that the state's attorney has its own association and there's a national association. I understand that you all are learning from one another, and I'm not sure that, I don't get the impression that you understood what our Madam Vice Chair is saying, which is we want to make good legislation. We want to help you. How are we going to do that with old data, particularly when we had COVID and all of that? I mean, don't we want information that is moving forward and not simply something that's a one-off report? Wouldn't we want something more? You're shaking. I know for a fact I would like to have current data. I would like to be able to, like when I was doing my driver's license suspension, I would like to know, is this a one-off, one individual terrible situation that happened just in my jurisdiction, just with one individual, that things went bad? Or is this more a systemic, statewide, or is it just that particular office? You know, I mean, I think we need, data's good, right? And we might be limited in what we can do with this because of our current financial issues, but part of this role is to find the money. Find it somewhere that could perhaps grow this task force and its function for all of us to make a better system. Does that make sense? I mean, does that make it make more sense of what the task force, as opposed to simply what you are already doing as a state's attorney association, why we might want this and to be on it?
We understand it, but I would also suggest that you also have GOCAP that began that process. And I think that it would be worthy to look and see whether or not it answers some of those questions, and money and funding and time has gone into that. And my understanding is that it's going all the way up to 2000 and what? 2000.
GOCAP is a database, right? So that you're putting information in. Why wouldn't we want to continue to have a task force or commission that would help us make GOCAP be the best it could possibly be?
Well, it's my understanding that, again, from the presentation that we received it's been about 3 weeks, that it's a dashboard that you can actually go to and see for each jurisdiction. That's what it was explained to us. And so that it may answer some of the questions that you're pointing out, as far as the ability to see what the trends are in each county.
It doesn't give me a place to go when it doesn't give me my answer. But the task force would give me a group that could help me make sure that in the future I can get that data.
I don't know that it's a panacea. I don't know that the task force is going to fix it all. Or it's 19 individuals, one representative of MSAA, when it's 4 states attorneys. I think that we're just thinking that, and let me just be clear, when we shaking my head, I was just kind of like agreeing and saying it's a dashboard, not a database, so on and so forth. But transparency and data is key. I mean, it's the wave of the future. I mean, you can't do anything without knowing data and understanding what you're working on so you can assess it and make it better. But I think that our point is the task force. How do the task force just convening is then going to have all of the answers? I don't know that that's the case. I think that we have a report that was drafted, that we should spend time focusing on implementing the recommendations rather than reconvening a task force. I think is really more of our point.
And we could always expand the task force if it doesn't answer our particular questions. It's a good, I mean, it sounds like it was a benefit. It sounds like it had a purpose that we still want, or, that we still are interested in and don't necessarily feel that it was fulfilled.
Isn't that so?
Yes.
Okay, so Delegate Crutchfield and then Delegate Phillips.
Very much, Madam Chair. So again, thank you for being here and presenting your perspective. GoCap's information, I think, is very limited, is what our issue is. I think we're talking about two different data fields. Usually the GoCap information is pretty much related to a crime. It may have information generically about the crime. It doesn't dig deep enough, I think, is what part of the issue is. And I think with the task force, the notion has been to dig deeper, really understand why an individual was prosecuted, understand the data behind that. And I don't believe the data at GoCap will provide that unless you have dug deeper into GoCap's information. I have not found that to be the case, but maybe you have.
So that's what we're saying. We haven't had the time. GoCap presented this to us about the first Thursday in March, and said they have been working for several years on building a dashboard that wins and pulls all of this information and as far as that. So one of the things that we feel that is important for us to take the time to look at that dashboard, and I don't know, maybe have the GoCap do a presentation before the various committees, one in the Senate and the House, so that it can answer those questions. So no, we haven't had the time to completely dig into it, but they did present to us and say it's a dashboard. It's going to give us the trends with the various crimes, and they've built that starting back to 2001 from the information they received from the court system.
Understood. But again, I think the issue with the task force is that it's going to dig deeper into what really the data is all about, okay? So I think that's one of the concerns. The other one is in Montgomery County, there was a disparity kind of study done. All right. And in that study, they did determine, again, the detail behind why certain plea deals happen, why certain prosecution decisions are made. And that's what the task force is going to be designed to do. That's going to go far and be far more far-reaching than anything that we can get from GoCap at this point, okay? And I think that's part of our concern here, is that it's not going to necessarily GoCap information. We get it. It's there. You are correct. They're collecting certain parts of information, but they are not going into the detail of why a prosecution happens, how it is done, what goes into the decision-making. And that's really what the information is supposed to be about from the task force. The task force is going to design that for us. So I don't think it's going to be duplicative, because that's what you're making it sound as though that they're going to really be doing the same types of data gathering, and I don't think that that's really the case here.
So I think the issue is probably why may not appear to be on the same page, or understanding is that it is not our understanding that the task force is going to do the work. The task force is going to make recommendations.
No, that's correct.
Okay.
That's correct. But they're going to provide the guidelines for the work, in order to get it done. That's what usually task force do, right? They provide guidance on what someone will do later. Okay, and I think that's where we're kind of getting off the train on, because that's really what we want is that's what the task force is supposed to be about. It's supposed to be about the guidance, and we understand that, yes, there's this data set out here that GoCap has, but it does not marry up with what the task force is going to do right now. So I think that's kind of where we are.
Understood.
Okay. Good, Delegate Crutchfield? Okay. Delegate Phillips.
All right, thank you, and thank you, Madam Chair, and thank you for being here. I want to kind of reiterate my colleague, but I just want to read this. Develop processes by which prosecutors can collect information and determine what information should be made public and what information may be kept private. And then it goes on to say a few other things. One of the concerns that I have, and I think the task force will help with this, is ensuring that we're collecting data that will be helpful as it's reported back to the legislature, that data is consistent, that data is transparent, and it's consistent among all 24 jurisdictions. We've talked a lot about the 4, and we understand that there's some leadership taking place We haven't talked about, the other 19, other 20. The other piece is, part of this, and a major piece of this, was to add to the task force job, figuring out how to attract resources, particularly for some of those smaller jurisdictions as well, because we want their data to be transparent and consistent, and once again, to be reflective of what the General Assembly is requesting. Do you all understand that?
Yes, sir.
And so you're saying we don't need the task force, but if we're the General Assembly and we're saying we're looking for someone to come back and report to us, this isn't about GOCAP. We want somebody to come back and be accountable to us. That's what the task force is for. You understand that?
Yes, sir.
Okay.
Okay. Delegate Conaway.
Thank you, Chair. Thank you for coming in to testify. So just in conclusion, are you saying that the data now is consistent and it's available? Is that what you're saying?
As far, for the dashboard, that's, as far as what we were told by GOCAP, is that there's data that they've collected, they've put in the dashboard that gives information about certain things that that has happened in all 24 jurisdictions.
But not everything.
Well, to say, I think to say everything it's never gonna be everything. So when you say everything, there are certain things that it is putting as far as, again, what has happened with the life of the case. So that information is supposedly in there. Again, we haven't had a lot of time to dig deep in it because, one, it hasn't been made public. GOCAP presented the information to the Maryland State's Attorney's Office to let us know they have been working on it and to have us start looking at it and give feedback on it.
Right, three weeks ago, is that correct? What you're saying, they presented it 3 weeks ago?
Yeah, they presented it 3 weeks ago.
But you've been working on it for 4 years and 4 months, is that right?
No. GOCAP was working on their own project, had nothing to do with the Maryland State's Attorney Association. We did not learn about their project until 3 weeks ago.
Okay. Thank you so very much.
Great, thank you. That concludes the testimony for Senate Bill, what was that? 343. Okay, we're gonna move on. I'm gonna skip Senate Bill 181 for now. Is there anyone here from Senator James's office? Great, come on down. We'll hear testimony. Oh, you've been here from the very beginning?
Oh, not the whole long, not the whole time.
Well, thank you for your patience.
I like coming over to the House.
Thank you for your patience. So we're gonna hear testimony now for Senate Bill 811. Whenever you're ready, you'll have 3 minutes. And I don't see anyone with you, so it's just you.
Yeah, I don't think I'll need the 3 minutes. So thank you. I saw the chair had to step out. Thank you, the vice chair and members of Judiciary. I'm here to present Senate Bill 811. For the record, my name is Samuel Deschanel. Senator James is legislative director. This bill is largely similar to House Bill 646, which has been passed by this committee. Was introduced by Delegate Taylor. And just a quick recap, what that bill does is it extends the deadline for the task force on the creation of a division on returning citizens and expanded reentry services. Just a task force just looking at reentry services and the feasibility of creating a new division to assist them. When the bill was presented when they were discussing the bill in the Senate, they noticed a drafting error. The bill, as introduced, extended it 10 months. The original plan was a full year. So the bill as introduced said October would be when the report was due for this task force. The Senate just amended that to say December, and that is the only difference between the House and Senate bills. So with that, I ask for your favorable report on Senate Bill 811. Thank you.
Great. Are there any questions? Yes, there is one. Delegate Taylor.
Thank you very much. The October deadline was intentional.
Oh, great. I was speaking based on what I had heard from the House, or from the Senate sponsor of the task force from last year, Senator West. So I don't know if there was a miscommunication or
There's
what.
no communication, but
that's
on that. But
Sorry
yeah,
about that.
it was an intentional October deadline. So, what do? Do I
Can we keep it?
Well, you just put that on the record, and
Okay.
so we have that record as part of the hearing.
Okay.
And we can take it back to the Senate and ask for the Senate to conform with the House.
Thank you.
Okay, that works. Thank you very much.
Thank you, Sam, I appreciate it.
Yep, thank you.
Senator Watson's office, come on down. We're gonna listen to Ms. Gray, Delna Gray, Legislative Director for Senator Watson for Senate Bill 46. Whenever you're ready, you'll have 3 minutes. Welcome.
Last but not least.
Well, not quite last, we got one more after you.
Okay. Good evening, everyone. Good evening, Vice Chair Bartlett, and members of the Judiciary Committee. For the record, I am Delna Gray. I'm representing Senator Watson from District 23, Prince George's County. Today, I'm here to present SB 46, which is a cross-file of HB 560, sponsored by Delegate Holmes. A similar bill, HB 164, sponsored by Delegate Conaway, who's a member of this committee, passed this committee as well as the entire House during the session, and we've made changes that are included in SB 46 to adapt to that, and we believe the differences can be worked out. The following provisions are a part of SB 46 that modify the wrongful detainer statute to ensure that property owners do not have to wait months to get their property back. Number one, the first change to the bill is that the court will hold a hearing within 4 to 7 days after the wrongful detainer complaint has been filed. The second change would not require the complaint to have the defendant's name on it. Instead, the complaint would just be addressed to the occupant of the property address because, of course, they would not know their names. The third change would require the owner or the owner's representative to provide a deed or other evidence to the court demonstrating the owner's legal interest in the property to prevent fraud. The fourth change adds the language that requires the sheriff or constable to immediately deliver possession to the owner or the owner's representative after the court has issued a writ of possession. The fifth change requires the court to enter a default judgment against the defendant if they fail to appear in court. The sixth change requires that any appeal by either party be held within 4 to 7 days of the court's ruling. All parties win with these changes passed by the Senate in SB 46. The wrongful detainer statute will provide due process for the occupant and a quick possession for the owner in as little as 9 to 19 days. I respectfully ask the committee for a favorable report on SB 46 and am available for any questions you may have. Thank you.
Any questions?
Yes.
Delegate Conaway.
Thank you, Mr. Chair. Thank you for coming in to testify.
Of course.
Since you named me specifically, do you know if there's any difference between that bill and my bill?
I do. Our bill, which was agreed to by the courts, the judges, and also the sheriff's office, said that all they needed was 4 to 7 days for the first hearing. Yours has 14 days.
I believe I submitted information from the chief judges.
Yeah, Judge Morrissey?
Yes.
Yes, he was the one, his office was the one who said all they needed was 4 to 7 days. Initially 4, and then at the greatest 7.
Okay. Thank you.
Any further questions? Seeing none, thank you very much. That concludes the testimony on Senator Watson's bill, Senate Bill 46. Now, members of the committee, you're going to have someone who looks very much like the vice chair doing her very best Senator Hedelman impression on geriatric and medical parole. And I will just not quite admonish, but mention to the committee that the vice chair is going to talk about Senate Bill 181 the way that it is, but perhaps will also reflect on some of the conversations that are happening regarding the difference between the House and the Senate bills. We're doing this as a courtesy because Senator Hedelman is in Budget and Tax, and they're doing the BRFA right now in the Senate, and Senator Hedelman's aide had to go home. And so the Vice Hedelman? Vice Senator Hedelman.
Thank you, Mr. Chair, and thank you to the members of the greatest committee in the House, the Judiciary. Way better than JPR. No, I'm just joking. Okay. Thank you for the opportunity to present on behalf of Senator Shelley Hedelman, Senate Bill 181. Maryland law allows both medical and geriatric parole opportunities, as we all know, yet requests for either are rarely granted. So this committee is aware that Maryland's prison population has skyrocketed in the past few decades. However, the dramatic influx into our carceral system is more attributable to longer sentences than increased crime. Current law enables anyone to apply for medical parole except those sentenced for a sex offense and those eligible for parole. So Senate Bill 181 permits an incarcerated person, family member, or other representative to request medical parole. We voted out in Judiciary House Bill 1123. It is not the cross-file of Senate Bill 181, but it is our hopes to eventually have the bills be identical. Have been in negotiation, as the chair said, and we have agreed to practically everything except for the mandatory risk assessment. The risk assessments are important because they help determine whether or not the person is or is not truly ready for life outside of the prisons, or the correctional facility. So with that said, we have raised the qualifying age to 65, as you will note in Senate Bill 181. We have also agreed to inmates who have served a continuous 20 years of their sentence and has not had a certain disciplinary infractions. So the only part that we disagree on, like I said, are the risk assessments. And what we are in negotiations. Senate Bill 181 sponsor would prefer that only geriatric individuals who are serving a life sentence receive the risk assessment because it is the fear that the backlog will not be addressed, because there is a huge backlog, that it will not be addressed, and adding more people to the risk assessment requirement would merely increase the backlog. So we are in negotiations because in House Bill 1123, we are adding more psychologists to do the backlog. At this point, we're trying to determine whether or not we could just limit it to those who already require, to codify those who already require a risk assessment, as well as give the MPC discretion and state that it would only be for a certain group of people who have a term of years of over 40. We have not come to that agreement yet, but we are working on it, and we are very close.
All right. Are there questions for the Vice Hedelman?
The Vice Senator.
Vice Senator?
Vice.
Seeing none? Oh, I'm sorry, Delegate Taylor, go ahead.
Thank you, Mr. Chair, and it had to do with the risk assessment. Just so I am clear, what we did with House Bill 1123, risk assessments were in there for everybody.
Yes.
What Senate Bill 181 is saying is that only require risk assessment for those over 65?
No, only require risk assessments when it comes, so for geriatric parole, we said everyone. So House Bill 1123 says geriatric parole, everyone gets a risk assessment. You don't need it for medical parole. So everyone gets a risk assessment. Senate Bill 181 is proposing that only the folks that would get a risk assessment would be those that are serving a sentence of life, because that is the standard practice now, uncodified practice of MPC, of the Parole Commission. And I only had 3 minutes, so I had to kind of go over it pretty fast, 2 bills, so.
Is there anything else you'd like to add?
Yes, thank you for asking that question. How much time you got? No, I'm just joking. No, but seriously, the bills are, we're so close. It really is the risk assessment on who's going to get, not who qualifies, but who's going to have a mandatory risk assessment. That's where we are, and that's what we're negotiating right now.
Awesome, thank you.
Further questions? Now seeing none, thank you very much. That'll conclude the testimony on Senate Bill 181.
Thank you.
And that'll conclude our testimony for today. It's only 7 o'clock. Thank you all very much. I would anticipate maybe not quite as late a day on the floor tomorrow, but perhaps a longer day in here tomorrow. And so just be aware of that. But until then, thank you all very much. This has been the House Judiciary Committee.